Professor Urok. Today I will speak about the Romanian experience, the Romanian constitutional experience in the field of environment protection. First of all, I have to point out that the Romanian constitution from 1991 was adopted and came into force after its approval by national referenda of 8 December 1991. In its initial version, it hasn't had a specific provision concerning the right to a healthy environment. The Constitution provided only for the obligation of the state to secure the exploitation of natural resources in conformity with national interests and the environmental protection and recovery, as well as preservation of ecological balance. In its chapter dedicated to fundamental rights, the Constitution connected the fundamental right to property to a certain specific environmental obligation, stating expressly that the right of property compels to the observance of duties relating to environmental protection and insurance of neighborliness, as well as other duties incumbent upon the owner in accordance with the law or custom. This constitutional provision had to be interpreted through Article 15, paragraph 1, according to which all citizens enjoy the rights and freedoms granted to them by the Constitution and other laws, and had the duties laid down thereby. So there was an incumbent duty for the owners to protect the environment, but there was no enacted explicit right for the human beings to a healthy environment. But I have to point out that even if the Constitution of Romania didn't have such a certain specific provision, it didn't mean that it had no laws in which protected the environment. For example, Professor Bondi spoke to us about the Stockholm Conference from 1972. You know, the Soviets and the states members of the Warsaw Pact didn't participate in that conference, but Romania in 1973 adopted a law on environmental protection, so after 1 year of the Stockholm Conference. Back to the Constitution. The Constitution was amended in 2003. It is the one and the only amendment to the Constitution. It was it was rewritten, actually, the Constitution. There were a lot of amendments to the Romanian Constitution, but only in 2003 was such a modification of the Constitution. In this amendment, in addition to the aforementioned norms, the derived Constituent Assembly introduced a new fundamental right in the catalogue of the fundamental rights and freedoms comprised by the Constitution of Romania, namely the right to a healthy environment. The new fundamental right is a social economic right and is provided by Article 35 of the Romanian Constitution, according to which the state shall acknowledge the right of every person to a healthy, well-preserved and balanced environment. The second indent of this article speaks about the obligation of the state to provide a legislative framework for the exercise of such right. As a consequence, the Constitution of Romania contains references to the environmental issues in 3 articles: 35, 44, right to property, and 136, 35, concerning the state obligation toward environmental matters. Besides these express legal norms, there are other texts in connection with these. Article 34, right to protection of health; 45, economic freedom, or Article 135, other paragraphs and letters than those mentioned. It was to be mentioned that in the entire constitutional history of Romania, as it has been for the first time when the constituent legislator provided for a set of fundamental rules and principles that concerns the protection of the environment. As a matter of fact, this initial openness of the Constitution of Romania to new values is accountable if we consider that a commission for the drafting of constitution created a documentary fund which included the constitutions of democratic states, studies in the field of constitutional law, international legal literature on matters that could be regulated by basic law, and initiated working meetings with the European specialists. But as we pointed out, the right to a healthy environment became part of the Constitution in 2003. It is when the fundamental right itself was enacted, the legal literature emphasized that this decision was a matter, of course, and took into consideration the intrinsic importance of this third generation right, the international and European orientations in the specific field, and requirements for the accessions of Romania to the European Union, where the protection of the environment represents a priority of EU policies. So this was the rationale of the text. In the legal literature, there were pointed out some guarantees for this right. The access to environmental information in compliance with the requirements of confidentiality, the right of association in environmental protection organization, the right to be consulted in the decision-making process concerning environmental policies, programs, legislation, the right to address the administrative and judicial authorities in environmental matters, and the right to compensation for damages. I've tried to find in the Constitutional Court case law a reference to the Arhus Convention, and I succeeded. The decision pointed out in the presentation. But let's say it was not a decision on the merits, on the hardcore of the Arhus Convention, but it was a decision about what does mean public, what is population, and how the population in the Romanian legislation can have access to environmental information. And the Constitutional Court said the term public is the same with population. Public was used in the Convention and population in the Romanian legislation. As concerns legislative framework for the exercise of this right, so as I mentioned, it is Article 35, Paragraph 2 of the Constitution. The general law on the protection of the environment is the Government Emergency Ordinance number 195 for 2005. Okay, when we are speaking about legislative framework, and I'm speaking to you about Government Emergency Ordinance, you will ask me, okay, but it has to be a law, not an emergency ordinance. Actually, in the Romanian constitutional system, we have laws adopted by the parliament, and this kind of legislative acts adopted by the government in, let's say, in emergency situations. And you will ask me, okay, but it was an emergency to adopt this ordinance? The answer is no. And I will have, let's say in a few lines, a bit of history. This kind of acts of the government were not used till 2000. Only from 2000, when Romania had to comply the accession requirements, use this kind of legislative acts, because it was more rapid than an act adopted by the parliament, and the government had the control on the content of the act. So the government preferred to adopt such emergency ordinances. So, as a matter of fact, an emergency ordinance has the value of a law. It is a law. Yes, it has to be approved ex post by the parliament. But till it is adopted, it has this approved by the parliament. It has the same constitutional value. In this emergency ordinance, we have a definition of environment that represents the set of conditions and natural elements of the earth, air, water, soil, characteristic aspects of the landscape, all atmospheric layers, all organic and inorganic substance, as well as living beings, natural systems interacting, quality of life and conditions that may affect human well-being and health. About this legislative framework, I studied the civil code. In the civil code, we have only two provisions that are specific on environmental matters. But let's say these two provisions are incidentally touch the environmental matters, because the most important act is Governmental Emergency Ordinance 68 for 2007 on environmental liability with regard to the prevention and repair of environmental damage. In the criminal code, we do not find, I think we find two offenses related to environmental issues, but the main sedes materia is Article 98 from Emergency Ordinance 195. Okay, I will refer to some constitutional court decisions that analyzed environment. What is environment? What are the obligations of the state? And I have to mention that in Romania we do not have the constitutional complaint. We only have the control of constitutionality of norms, so review of norms. And that's why maybe you will say that, okay, the case we will present, it is to link with the norm and not with real situations. Yes, it is true, because in Romania the Constitutional Court has only this competence. So we have positive obligations of the legislator. I've tried to put down some kind of these positive obligations. Like when you want to build a building, you need a building permit. The Constitution, I've put in brackets the Constitutional Court decision and the concerned paragraph. I won't read the Constitutional Court statement on this, but I have to emphasize that the court used the environmental effect of building all the time and without a administrative control. Another kind of permit, the environmental permit and the integrated environmental permit. This is used in Romania when you want to build something that sure will affect environment, and that's why you need this kind of permit. So it's limit your economic, let's say, rights and property rights. Hunting permit, the same. As regard hunting permit, it was a very interesting decision of the court when some people, let's say, exercising their right of property, said, okay, but my land, it's a hunting fund. Why you come and hunt on my land? Because you destroy the crop from the land. And the Constitutional Court emphasized that hunting is for environment protection, even if it sounds a bit barbarian. Another question on which the Constitutional Court was to had to answer, if the legislator may impose to economic operators who pollute the environment a certain tax or contribution to the environmental fund. The court, of course, agreed with this stance of the legislator. Restrictive regulation of the areas in which smoking is allowed. In 2015, the Romanian legislature adopted a law in which you are not, and of course you were not allowed and you are not allowed at the moment to smoke in closed halls. The court emphasized that it is for such a measure protects directly and indirectly the environment. Another case, it was a very recent case on migratory birds, and the court for the first time talked about preservation of biodiversity. Animals. I was speaking about hunting permit, and now I will tell you that in the court case law, animals can be seen as an integral part of a sustainable and ecologically balanced environment, healthy nature. And this is a benefit for both and present and future generations. It is the sole reference of the Constitutional Court to generations, to future generations. I didn't find any other decisions of the Constitutional Court, and of course the Romanian Constitution has no reference to future generations. Because I think future generation is an integral part of the right to a healthy environment. I tackle the problem in this legislative framework about the relationship of Article 35 with other constitutional rights. The most relevant relationship that I found in the Constitutional Court case law was the connection with the right to private property. As you've seen, the Civil Code defines private property as the right of the owner to own, use and dispose an asset exclusively and absolutely. So it was a problem. What does this mean, absolutely? You have limits, and in another two decisions, the court says it has to harmonize the incidents and other fundamental rights of citizens other than property rights in a systematic interpretation of the Constitution. So it is the task of the Constitutional Court to do this. A law that bans the change of the destination of the lands arranged as green spaces or provided as such in the urban planning documents, the reduction of their surface or their relocations is limiting the right of property. But the Constitutional Court, as my colleague from Poland said, made a proportionality test, suitability, necessity, and proportionality stricto sensu, and said, yes, you can do this. Of course, when we are speaking about ownership of forests, ownership of a land that is part of a hunting fund, the right of property is limited, and this limitation of the property right is justified by the reference to protection of the environment. Sanitation activity on private properties is the same, and I've told about building permits. As I said at the beginning, there are certain articles that are in direct link with the healthy environment, with the environmental rights. For example, Article 13.4 guarantees the right to protection of health. And in the Constitutional Court case law, I found some decisions that make this connection between healthy environment and a healthy person. Another text which speaks about the access to the economic activity do not have a reference to environment, but the reference is implicit, I think. And another three texts, 35, right to environment, 45, right to economic activity, and 135, state obligations in the field of economy, were analyzed together by the court when it came about the change of the boundaries of the protected natural areas of national interest. And it was about mining. In this case, the court agreed to put these boundaries of the protected national areas to the level of 2007, so the territorial areas, in order to permit some mining activities. What about the relationship with the EU law or with the jurisprudence, case law of the European Court of Justice? The Constitutional Court of Romania has an older decision, 668/2011, when it said that the contradiction between the national and the EU norms does not per se constitute a breach of the norm of reference in the review of constitutionality, namely the Constitution, but may be an argument to demonstrate a breach of the Constitution. In a recent decision in 2018, the court stated that the constitutional relevance of EU norm is absorbed by the constitutional norm, which enshrines the protection of the fundamental rights to a healthy environment. Practically, the court says, yes, you have at the European level a certain acts, certain norms, but my constitutional norms absorbs all these obligations into it. I pointed out in the next 4 points some infringement procedures against Romania. They are pending, and those two, which are written with black. You had the first ECJ judgment, failure to fulfill obligations in environmental matters, and the second, failing to fully comply with the court judgment from 2018. And it is a pending procedure. It is about landfill directive. About the European Court of Human Rights, I want to point out one decision. In 2009, in Tatar versus Romania, there was an environmental accident. The dam has breached, releasing cyanide-contaminated tailings water into the environment. State authorities didn't act for the, let's say, for the health of the peoples living next to this contaminated area. And the European Court of Human Rights pointed out that the state had the duty to guarantee the right of members of the public to participate in decision-making process concerning environmental issues, one, and the failure of the Romanian government to inform the public, in particular, about not making public the impact assessment, on the basis of which the operating license had been granted, had made it impossible for members of the public to challenge the result of that assessment. The Romanian authorities failed in their duties to assess to a satisfactory degree the risk that the company's activity might entail, and to take suitable measures in order to protect the rights of those concerned, to respect their private lives and homes. So the European Court of Human Rights made a connection between Article 8 of the Convention and the environmental issues. So even if we do not find in the European Convention of Human Rights a special article to a health environment, it is intrinsically contained in Article 8. So, ratione materiae, it is within the competence of the European Human Rights. And last slide, and I promise that I will finish in 3 minutes. I said I have to have a part in this material about the mechanisms of control when it comes about environmental issues. First of all, we have at parliamentarian level the inquiry committees. We had a case in Romania about gold mining, Roșia Montana Gold Corporation. We had 2 parliamentarian inquiry committees, I think in 2001 and 2013, and the parliament set up some reports about all this activity. I won't enter into detail, but in my paper you will find all these details. Another mechanism of control is the ombudsman. In Romania, we have an ombudsman appointed by the parliament. The ombudsman is provided expressly in the constitution, and the ombudsman in Romania has, let's say, vice ombudsmans on different domains. And we have an ombudsman that has this field of environmental protection. And in 2011, it has 99 petitions to resolve, and in 2020, 174. That is only 1% of the whole activity of the Romanian Ombudsman. And 2 specific aspects about the Romanian Ombudsman. In 2011, it participated actively to to put Roșia Montana into UNESCO's World Heritage List, and this happened in 2028. And in 2020, it had a special report on the protection of the forestry areas in Romania. And I will skip on the administrative bodies, and I will go to the prosecution on forestry offenses. Between 2011 and 2016, so in 6 years, we had 429 convictions. But the main problems in this specific matters of forestry offenses, that the courts do not punish severely the persons, the perpetrators. The punishments are often with the suspension of the execution of that punishment. And as regards other environmental offenses, so besides forestry offenses, that were committed in the same period, prosecutors had a solution of indictment in only 4 cases out of 822. And of course, another mechanism of control are the administrative bodies. I want to emphasize a specificity of Romania about the Danube Delta region, where we have a specific authority that administer and control this specific area. So I think that it is important to know about all these mechanisms of control because they have constitutional value, so the inquiry committees of the parliament are enshrined in the constitution, the ombudsman is in the constitution, and of course prosecution has its regulation in the Romanian constitution too. This was my presentation. Thank you very much, and of course the detailed presentation you will find in my chapter or paper. Thank you.